Hello, my name is Thomas Nägele and I'm doing a presentation about the Liechtenstein Blockchain Act. Its real name is Token and TT Service Providers Act. Short disclaimer first, this is not legal advice. If you need legal advice, please consult your local counsel. Coming to my person, as I said, my name is Thomas Nägele. I'm an attorney at law, but I also used to code software for about 10 years. We do blockchain advice since several years now. We started actually 2015. And I was also a member of the Liechtenstein government work group to draft that Liechtenstein Blockchain Act. So I tried to build the bridge between technology and law. Today's presentation, I hope that I will be able to give you 4 key takeaways. The first will be the token container model. A second one, the registration for service providers. Third, the security token lifecycle. So we'll talk a little bit more about primary and secondary markets. And fourth, the draft of the European Commission about a market in crypto assets regulation. I will start with a short introduction to the Principality of Liechtenstein. It's worth noting that we are a very small country. We are in the heart of Europe. We are bordering Switzerland on the one hand, and on the other side we are bordering Austria. It's a 35 minutes car drive to Germany, for example. And as I said, we are a principality, but we have a very strong financial center. Compared to the size of our country, we have 15 banks, more than 400 trust companies, 116 asset managers. But we also have 21,000 commuters. I mean, we are a very small country, so we need the commuters from Switzerland and from Austria. We are a AAA rated country, and we have approximately 38,000 inhabitants. What is special about the situation of Liechtenstein is that we have, on the one hand, we have special agreements with Switzerland, but on the other hand, we are also a member of the European Economic Area. So we are not a member of the European Union, but we are a member of the European Economic Area, which gives us access to the European single market in some respects. So for example, if you want to set up a bank and you want to provide your services to the European market, it's in the same way possible via the so-called passporting regime as you can do that out of Germany or, for example, out of Austria. And coming to the dedicated law, so the Liechtenstein Blockchain Act, I would like to start with just a brief overview and some basic facts. It's a 58 pages law. It has 51 articles, and it has a full report with a lot of additional information, about 380 pages. You can download for sure all of this information via the public websites. I have provided here some links. What is worth noting, they're not only in German, most of it is available in English as well. Coming to the token container model, one of our 4 key takeaways of today's presentation. Because the way Liechtenstein approached these new technologies is a little bit different to the approaches we saw before Liechtenstein was actually publishing its approach with the dedicated legislation. Because in the center you will find the definition of token. And the act was actually drafted in a way that it could serve as the legal framework for tokenization of assets. So it is actually the legal framework for the token economy. And for those of you who don't have some clear picture about the token economy, there is no clear picture, but in the end, it's about digitalization of our economy with the use of token. So every process you have now in your mind when it comes to providing services or producing products, if this process can be digitized, in some areas, it might make sense to use token to do that. That's why it was drafted very technologically neutral. So it's not talking about blockchain or DLT or whatever. The act itself is using the term trusted technology to be future-proof. And in the center, the definition, you have a definition of token. Token is a piece of information on a TT system, where TT system, as I said, stands for trusted technologies. So for example, blockchain or DLT. So whenever you hear that, you can think of blockchain and DLT, which can represent actually almost any right. Like one of the main examples are your shareholder rights. So you can have your shareholder rights represented in a token. But for example, what is also possible is ownership right. And what is also in the definition is that you have this token has to be able to be assigned to one or more TT identifiers. That's another term we introduced. So we are not talking about addresses or public keys, as you might have heard of already. We are talking about identifiers, again, to be as future-proof as possible. Coming to that token container model, I always start with that basic ERC20 token smart contract, because this represents the braces here in that picture. And so you start with that token, which is an empty container. That's why it's called token container model. And you start with that empty container, and you have an asset, let's say a diamond, and you can actually have define a right, let's say ownership of that asset, and then let the token represent that ownership right. And then you can use the whole power of blockchain to transfer the token to actually define other rights based on that. That's also possible. And in general, like this is the main concept, how you tokenize assets. You define a right and then you let the token represent that right. I just had one picture here with one of the service providers. We will have a very short look on afterwards, the physical validator, which will in some cases take the physical object in custody. And this allows you to let the token represent basically any right. Yes, there are some limitations based on mandatory laws, but in general, any right you can let the token represent. Securities, intellectual property, utilities, assets, as I said, ownership rights, for example, or others. And the question was, I mean, what's that good for? When we started to think about regulation in 2016, there was one idea to just don't have a specific regulation. Let the technology evolve and let the technology be innovative, and let's find some new ways of how you do things. But in the end, we realized that if you have that picture of the token economy in your mind, and you think of the challenges you have from a legal perspective, you at least Liechtenstein ended up with the answer that no, you need some amendments of the legal framework. And that's why Liechtenstein introduced this token or this specific law, this Blockchain Act, and it's in force since 1st of January 2020. And the result here is that you will get legal certainty, because when you transfer a token, that's a very big question from a legal perspective. If you transfer a token and you say, okay, I have an ownership right, and this ownership right is represented within a token, and if I transfer the token, that's fine. I'm the owner of the physical object. But from a legal perspective, it's not that simple. So the idea or the goal is that if you dispose over a token, this also results in the disposal of the right represented by the token. As I said, if you transfer a token representing ownership, you want to be the owner afterwards. And the Liechtenstein Blockchain Act has specific provisions to provide this legal certainty. So you can think of that in a way that if you transfer a token in the blockchain world and you have a suitable legal framework, this will lead to enforceable claims for real world assets. And I mean, you can think of it like you have now the legal framework and the legal certainty for all of the things you can imagine when you have a lot of assets which are at the moment not tradable, you can make them tradable, for example. But on the other hand, if something goes wrong, you have the enforceability as well. If you think of the token economy, you have to have this legal certainty in place. Otherwise, this will not flourish, I think. Coming to the service providers, because this technology started with the idea of getting rid of the intermediaries, with providing only technical solutions to the way of how we transfer values. When we thought about providing the legal framework for it, Liechtenstein answered also with that act that some even new intermediaries are needed to provide this legal certainty on the one hand, and on the other hand to protect the consumers and investors. And so I will guide you through the service providers the TVTG introduced. We have these new intermediaries, and you see them here in one chart. So these are all of the new intermediaries we have in place now. We will come to the registration procedure in a minute with the local financial market authority. You can think of, I think, you will recognize some familiar terms like TT depository or exchange service provider. We already touched briefly on the physical validator, but there are even some new ones like verifying authority. So what are they good for? The token issuer is a person who offers a token to the public. So think of the phase when you have a public offering of a new token because you want to finance your company. You do a crowdfunding campaign or an initial coin offering. Under certain circumstances, you need to be registered as a token issuer if you do that and if you offer tokens to the public in your own name or in the name of a client. Also regulated is the generating part of a token. So if you generate a token and you do that in a professional way, you have to get registered with our financial market authority first. Then we have the Trusted Technologies Key Custodian, a person who holds token in another person's name for another person's account. That's one of our main registrations. Then we have the TT Protector. I will not go into much detail here. The difference is the disclosed proxy from the key custodian to the no disclosed proxy with the TT Protector. And then we have the exchange service provider. So think of all of these big crypto exchanges, persons who exchange legal tender for token and vice versa, and as well token for token. Then we have some specific roles like the TT service provider or the identity service provider. And as I said, the physical validator who ensures that the contractual enforcement of rights to properties represented in token on TT systems are defined by property law. In the end, this role builds the bridge between the physical object and the rights you have represented in a token. Coming to the registration requirements in Article 13, basically you have personal requirements, you have organizational requirements, and you have additional special requirements based on the service you want to provide. I will not go into detail, but in general, there's an overview I will come to in a minute because this really depends on the specific service you want to provide. Worth noting here are, for example, the minimum capital requirements or that you have on specific roles you have to have internal control systems in place. This is an overview of the roles and the requirements. I think what is interesting here that if you look at the procedure, you have to get registered with our financial market authority, which is and it is not a licensing procedure, so you will not get a license. In the end, you will be registered with the financial market authority on their website, and we'll have a look at that as well in a minute. So we will start with your application. You will fulfill all of the requirements, and you can actually see, on the website of the Financial Market Authority, you find a lot of additional information about the requirements as well. And we have on our website as well an executive summary. You will file a submission. You can do that electronically, and you can do that in English. And the FMA then has 3 months to decide whether they want to register because you fulfill all the requirements, or not register you as a service provider. And I mean, if we look at now the status quo of that register, because we started, as I said, in 1st of January 2020. At the moment, we have 11 companies registered for 25 services. And because I have information about, it was status of October 2020, how many companies were in the process of getting registered. So I just divided that number, and so we have at least more than 9 companies in the process of getting registered. I don't know for how many services. You can check that register yourself. The website is actually at the bottom, fma-register.fma-li.li, and you can see who is actually registered in Liechtenstein. So we now touched the token container model, now I would like to touch the life cycle of a security token, so a financial instrument represented in a security. And we'll start with an overview of capital markets, very briefly, to give you any idea where are the challenges and opportunities here. Primary market, we heard of the initial coin offerings, the ICOs, which are not financial instruments, hopefully, because these were the ones we had in 2016 and 2017 and 2018. But then it changed, and then we had the first security token offering in Liechtenstein, which is the primary market. You write a prospectus, get the prospectus approved by the Financial Market Authority, and then you have the offering. But after the offering, you want to have liquidity. You want to actually sell your security token, maybe, and therefore you need the secondary market, which is a little bit more complex than just the issuance part of it. As I said, we had the first security token offering out of Liechtenstein in August 2018, which was the first security token offering in the European Economic Area, so European Union plus EA, ever, with approved prospectus by a regulator. Coming to the secondary markets, so in simple terms, think of secondary markets as your exchanges. You have actually 2 ways of organizing your exchanges. One way is that you have like the existing securities world for financial instruments, exchanges, multilateral trading facilities, over-the-counter trades. These are really heavily regulated for good reason. You have intermediaries which are subject to regulation, and on the other hand, because if you are regulated and if you have a license in one of the member states of the European Union or the European Economic Area, it's a harmonized regulation, and this allows you to passport your products and services to the European single market. On the other hand, you have the crypto exchange world, where you don't have this harmonized European Union approach. Every member state is doing his own thing at the moment, so there is no harmonized regulation. Therefore, you have, depending on the member state, you have specific laws, as we have in Liechtenstein, as we heard with the TVTG, a local regulation. What is really interesting is the opportunity here that we have now this draft of the European Commission of this market in crypto assets regulation, because this might provide then in the end, if you analyze the draft, the opportunity to provide your services again to the European single market. So think of a crypto exchange where you can actually provide your services to the whole European Union and European Economic Area. And you have the decentrally organized exchanges or the secondary markets. You might have heard of the term decentralized exchanges, DEX, which deal both worlds, financial instruments in a tokenized way and crypto assets. There is no intermediary. There's nobody. If it's really a fully decentralized exchange, and all of the parts are really decentralized. So trading, clearing, and settlement is done completely decentralized. Then there is no intermediary to regulate. Like all of the risks are mitigated through the technical design of the decentralized exchange. There's less legal certainty for sure. There is a lot of question marks here. And this is actually true for all of the DeFi products as well. Because yes, if there is nobody to regulate because there is no intermediary, there is no emitting party, there is no company providing these products and services, yes, this might not be regulated, but on the other hand, the problem is that you have nothing or no claim against nobody. In the end, you have to think for every product and service you want to provide, what is your target market? So where would you like to provide your product and service for? So if you do that for the European Union market, it's actually worth considering a member state of the European Economic Area of the European Union, because then you have the access to the single market in the harmonized world, so where you have like harmonized legal frameworks. And on the other hand, if it's about crypto assets, think about MiCA, because when MiCA is in place, this might provide a really big opportunity here. Coming to the MiCA, as I discussed it already, the Market in Crypto Assets Regulation was published in September 2020 by the European Commission. And it's a EU-wide crypto asset regulation. So it's a regulation. It's will be, if it is enforced, in every member state automatically. Besides that, there's also a pilot regime for market infrastructures on DLT. That's a really fascinating topic about how they organize the secondary market for financial instruments with a pilot regime. And there are a lot of lessons learned they have here, and therefore it's really worth to have a look at this piece of regulation. I have an article published about that as well. You can download this text here as well in English and some other languages. What is introduced by MiCA in comparison to the Liechtenstein Blockchain Act, MiCA has a category or several categories of token. So they have something which they call asset reference token, basically for stable coins and some other essence reference tokens. They have utility token, where you have like you're providing a utility, or the token is providing a utility. E-money token and a catch-all definition, but this is now on the discussion if the catch-all definition, how this will look like for all of the other token. What is really interesting is that you also have in that digital finance package, the goal of the European Commission has the idea to amend MiFID and to amend the term financial instruments. So this is the term you will find now in that directive. Financial instrument means those instruments specified in Section C of Annex 1. And the idea is here to propose an amendment which says, including such instruments issued by means of distributed ledger technology. This is actually this has two consequences. One is that then it's pretty clear that if you have a financial instrument and you want to represent that, or you want to use distributed ledger technology to issue that or to provide services for that financial instruments, you can do that, because the fact that you're tokenizing something doesn't change the nature of it. That's the good thing here. And on the other hand, it's pretty clear as well that there is something which is a financial instrument, and you have a token now which represents the financial instrument. And on the other hand, there are a lot of other tokens which the European Commission calls crypto assets, where they are not, and clearly not, financial instruments, which is a very good thing, I think. When you look at the MiCA draft as it is now, you also find some service providers, as for example the trading platform, exchanging crypto assets versus crypto assets and fiat, custody and administration. The key benefits of that regulation is, as I said, the uniform conditions, and therefore you will get full access to the European Union market and the legal certainty necessary to promote innovation. And it's in the form of a regulation, as I already said. Which brings me to the point, might that be something which is interesting for, I mean, in the end, if this isn't then enforced in the European Economic Area and in the European Union, this might also be enforced in Liechtenstein, and why do we need then an own legislation here? But if you look at that picture, you will find on the left side the regulation of MiCA and the service providers they're going to regulate, or what the proposal is talking about. And on the right side, you will have our TVTG registrations. And you see some similarities, and this small graph shows you the level of regulation. And I will not go into detail, but the interesting part here is that MiCA also has one paragraph about that if you are already regulated in a member state by the time of the entry into force of MiCA, then it is possible to provide a simplified procedure for applications. So in other words, if you are already providing services out of Liechtenstein based on TVTG of the services and the regulations and the registrations we just talked about, so for example providing exchange services, you might have an easier way to getting licensed than based on MiCA, which is a good thing, I think. Coming to the summary. So we are now, if you want to put the TVTG or the Blockchain Act on one page, that's my try to do that. In the center, you have the token definition, the token container model in a sense, where you have defined the token, which is the container, which can represent rights. Then you have specific functions of a token. We didn't touch into that today. Legitimization, liberation, and transportation, which you might have already heard when it comes to the securities world. Then we have the relationship model between TT keys and TT identifiers. We didn't touch too much into detail there as well. But in the end, if you have a token, you have to have a link to the physical person. Then you have the Article 7, which provides the legal certainty that if you dispose over a token, you also dispose over the right. And what is the idea of the Liechtenstein Blockchain Act? It's to provide the legal framework for tokenization of assets, or the legal framework for the token economy. And how is that done with the Liechtenstein Blockchain Act? You have an asset, you define a right, and let the token represent that right. We have newly introduced service providers, which have to get registered with our Financial Market Authority to provide services out of Liechtenstein. The 4 key takeaways: token container model, as I said. Second one is registration for service providers. And third, the security token lifecycle, where you have a lot of opportunities at the moment as well, and the draft of MiCA. I have some further readings, which are all open access, so free to access and in English. We love your likes if you want to get in touch with us. If you have questions, you can always reach me via my email address, tn@nägele.law, or visit our blog. And I want to thank you very much for listening to today's presentation, and happy to answer your questions.
토마스 변호사님하고 예 계시네요.
Yes, I'm here.
토마스 네겔레. Yeah, I'm sorry, my pronunciation is bad, but thank you for your presentation, Thomas.
Thank you very much for having me. It was my pleasure.
Yeah, would you say hello to the Korean businessmen in blockchain industry?
Hello, pleasure to meet you.
Yes, I have some question to today's presenters. Yeah, first one is to Thomas, with Dr. Nägele. I'm sorry. Yeah, in your presentation, the STO is allowed in Liechtenstein. Would you explain the advantage in Liechtenstein comparing to Switzerland? Yeah, it's a tricky question.
I think if you want to compare these two jurisdictions, I mean, every jurisdiction has its pros and cons. Like if there are some advantages in Liechtenstein, there are some cons as well. Same in Switzerland. That's what we, since we advise on these areas since 2015, we see that some projects are betterly placed to Switzerland, some projects are betterly placed in Liechtenstein. Coming to the security token world, I mean, we all heard today that whenever you do an offering, whenever you do something publicly, you want to actually attract the world. And we had the presentation about the situation in the United States, and we had the presentation about the situation in Europe and everywhere else. So the problem is always, if you have a target market, it's really, if you define the target market as the world, you will anyway have a lot of regulatory problems. But the good thing is that with the securities world, you have a harmonized approach in Europe. So if you are approved by one European regulator of a European Economic Area membership country, you can passport your services to all of the European countries. So, which means when we did that the first time in August 2018, what we did is we asked our local financial market authority, provided them with a prospectus, and they approved it. And afterwards, the clients were able to passport this prospectus to the whole European Union. So they were able to attract the 400 million market. Coming back to the size of Liechtenstein, if we would not have been a member of the European Economic Area, we would only be allowed to attract investors in Liechtenstein with a population of 36,000. So that's actually one of the advantages, I think, being a member of, for example, the European Union or the European Economic Area. On the other hand, I think that's also because we did that the first time in August 2018, as I said, and now we have a lot of experience with doing that. So, for example, in Liechtenstein, it's also possible to provide equity instruments. So not only bonds as in other European countries, really equity instruments. And what is really interesting now is that having that said, that even the secondary market is going to form on a European level again. So if you have done all of your work for your local jurisdiction, I mean, then you're locked in. That doesn't help you a lot. So the good thing here is that you have one bigger target market with one regulator to deal with. And I think that's the main advantage when it comes to the securities world in comparison to Switzerland. There are some challenges as well, and I don't know if you want to add something here, but I think that's the unique situation of Liechtenstein, being in between of Austria and Switzerland, having access to Switzerland as well, because the prospectuses of Liechtenstein can be easily transported to Switzerland. There's an easy procedure to do that, and on the other hand, you can easily attract the European Union.
Yeah, thank you. Do you have a chance to work with the Korean company in Liechtenstein?
Yes, we do. I mean, there are some, I cannot disclose any names, but there are some, but it's rather at the low end. We have more clients at the moment, and I don't know why, is that the reason? Because we have a lot of clients from Southeast Asia, actually, but not, and only a limited number for Korea. So I'm happy to have any questions about why not coming to Liechtenstein.
One more question to Thomas. Is this right understanding the level of AML regulation or the financial regulation is similar with other European countries?
I think from a compliance part, we are rather at the higher end of complexity. So it was pretty clear that the Liechtenstein government wanted to have a strong compliance framework around these new technologies. And even compared to the European standard, I think we are at the European level or a little bit above that, actually. Because we wanted to have clear businesses only. That was the goal here in Liechtenstein, to have regulated and clear and good businesses here. The overall regulation or the overall regulatory environment, I did the comparison with MiCA and with the TVTG. That the MiCA is the European approach now, which is dealing with crypto assets. I think that the Liechtenstein approach is it's very comprehensive. We put a lot of effort in analyzing the whole legal framework. So we heard, for example, that the Swiss approach is that they regulate, they amend a little bit of their laws to make it possible to issue securities in a digital way. I'm not a Swiss attorney, but in general, like that's the concept as far as I understand it, and that's what we see from other regulators as well. They try to amend their securities laws to make digital securities possible. We did that as well. So we amended our corporate act as well, but we did way more than that, because that's just a part of the story. The story is way bigger. It's about tokenization of assets. So if you go the securities approach, as for example some other countries, if you want to tokenize a piece of art, what you do is actually you found a company, as we all know, a special purpose vehicle, and then let that company buy the piece of art. And what you do is you tokenize your shares of the company. But in Liechtenstein, the cool thing is you can get rid of the intermediate company, the SPV. You don't need an SPV anymore. You can literally tokenize the ownership right of the piece of art. And that's the groundbreaking difference with that legislation in comparison to all of the others. Because yes, you can do the same thing with the securities. It's possible to do that in Liechtenstein. It was possible since 2016. So that's forever actually in Liechtenstein. Almost it was possible. It felt like almost 100 years now. But what we did, we said, okay, but it's more than that. It's tokenization of everything. It should be possible. And our concept is, if you have a right, you can actually let the token represent that right. And that's why it's so comprehensive. And we had to amend our civil law as well to make that possible. And now what we see is a lot of attraction there and a lot of interest there, because this new concept was not known before. Because the securities world is known, but the new concept of really doing that without an SPV, that's the interesting part, because you just save costs.